Hearty afternoon to all of you old sports out there. This is your fellow Social Security attorney, Andrew Sendler, here on this fine Wednesday, July 23rd, sunny afternoon. So glad to see all of you once again. It's been quite a long time, and I am just getting ready to leave to go on my summer vacation, but wanted to make sure I took the opportunity to get my next video topic posted for all of you. As you all know me well, I try to post videos on related and relevant topics to the theme of my channel, being Social Security disability, which I'm still chucking along 20 plus years later and learning and growing with all of you. So hope you'll appreciate this. This will actually probably again be one of my shorter videos, which I'm guessing some people might appreciate. Um, but it's on a very important and relevant topic, and somewhat serious topic, some might say, because this is something that comes up pretty much anytime I encounter a claim, no matter what the circumstances or facts of the claim are. So it will all make sense once we get into it. Without further ado, let me share my screen to get to our PowerPoint presentation, and then we can get started. So it would help if I find the right thing. There we go. Okay. All right, let's get the slideshow underway. Get myself moved out of the way. All right, so today's topic, disabling does not equal debilitating. To be or not to be disabled versus debilitated. So, as I said, this is a topic that comes up almost invariably in my cases. I have so many um, clients with so many different types of impairments, physical, mental, cognitive, you name it. And they all experience them completely differently, completely individually, completely uniquely. And the common denominator with all of them is that the concern about whether or not a claim needs to show that a person is actually completely debilitated versus as to being an invalid versus the actual requirement is something that comes up very regularly. So that is what I'm going to talk to all of you about a little bit, and hopefully you'll get some good information and feedback from this. And this is the first time I did a slideshow. I kept it black and white because it is a very black and white topic. But even though there is, I think some people might say some gray area. Also, I have no fancy animations on this one. I wanted to keep this one just simple and straight to the point. So that's what we'll do. There's not even that many slides to go over, but I will try to hit my point as we go through. First, of course, my About Me slide. That's the only one that has the usual animations because it's the same slide I use every single time I do these videos. There's my information for you. I'll leave it up just again for a moment. It's on every single video and PowerPoint that I've done to date. Um, but this pretty much sums up everything is pretty much the same as it's always been for me. All right, let's get right into the actual topic. Oh, I guess I must have some hidden animations because I didn't actively put them on this time. So I guess we'll get to it. All right, so first a quick refresher for everyone. Disability defined. Social Security disability claims are premised on a person's ability or inability to work a full-time job consistently. So, how do we go about proving this? Well, I harken back to my ABCs of SSD original video that started this channel almost 2 years ago, back in August of 2023. Refresher for everyone, the five-step sequential evaluation process. Step one, are you currently working? Step two, do you have a severe medical impairment? Step three, does it meet or equal a listing? Step four, does it prevent you from doing your past relevant work? And step five, does it prevent you from doing any other type of work on a full-time consistent basis? That's what you have to go through. You have to answer all those questions the right way with evidence to support them in order to prove disability. So the question that then begs is, why does it sometimes feel like that's not enough? And that's what leads to the topic that we're here today. We're here to talk about today, I should say. So, disability from working. So, I get this question regularly from clients, actual and potential clients. If I can't work, isn't that enough? Or do I really need to go out of my way to show how disabled I am in just everything I do? And the topic usually comes up in light of claims that get unfairly denied, which happens very regularly. You ask any Social Security attorney out there, there's nobody out there that doesn't have about a million war stories at the ready of claims that they just drop their jaw to the ground in disbelief that the claim ever could have possibly been denied. There's just no rhyme or reason to it. And it does beg the question oftentimes, how severe does it really have to be? I mean, do I really have to go out of my way to show that I'm a complete invalid? And what's interesting is there's that school of thought, but then there's another school of thought of people that will constantly bring to me war stories on their own of knowing somebody that's on disability that in their view is far less disabled and impaired than they are. So that's where this topic kind of has its roots. So, as I always have highlighted, and I've referenced this in many of my videos because it comes up, steps 4 and 5 of the sequential evaluation process are the ones that matter most because that's how disability is established. At step 4, you establish that you can't do your past relevant work, and at step 5, you establish there's no other full-time work you can do on a consistent basis. That, in and of itself, makes a claim golden. That's what you need to be able to show in order to prove disability. Disability is therefore about, and I highlight this word because it comes up all the time in presentations I've given, including the one I'm about to be giving in September in San Diego at the national conference. It's all about consistency or lack thereof. Point blank, if you can't consistently work a full-time job, you are disabled. Now, you again, of course, have the burden of proving that you can't work consistently a full-time job, but that's what disability is about. And nobody should ever lead someone to believe differently at the end of the day. So, how is that different and how is it relevant when we talk about disability from living your own life? Many people who have severe medical impairments certainly don't want to let the impairments define them and certainly don't want to stop them from living their lives. And many people just straight out of the gate won't allow that to happen, nor should they. When you think about medical impairments, again, whether you're talking about physical, mental, cognitive, any combination of them, no matter how severe they are, many of them tend to be of a nature that you're going to have these quote good days and quote bad days. But that begs two questions as to whether someone's disabled. The first one is just because you have a quote good day or two here and there, does that mean you should be able to work a full-time job consistently? And two, more importantly, would an employer tolerate that? Would they tolerate somebody who can't consistently perform work because of their bad days or even just bad moments? I mean, a whole day isn't necessarily ruined when you have an impairment that flares up on you. But if you have one of those bad moments and you have to go to your supervisor or your coworkers and say, I'm not going to be able to get this work done right now. I need to take a long break, or I need to you know, refocus. I need to reset. I need to clear my head. I need to, go rest, lie down, whatever it is. Are they going to tolerate you being off task during the workday? We talk about this all the time. Are they going to tolerate you arriving late if you wake up and you're not having a good day, physically or mentally? Or you have to leave early because that flare up hit you out of nowhere? Or if you have to call out altogether because this is just a bad day all around? Will they allow for that? And the common sense answer to that is, of course, they won't. You ask any employer out there, no matter how simple or unskilled the work is, they need to get productivity out of their workers in order to justify keeping them unemployed and keeping them paid. And that fact has nothing to do with disability. That's just simple economics for you. That's how society operates. Employers and businesses don't make money if they're not getting the productivity out of their workers they need. We've talked about this a lot on other videos, particularly I think We hit on it a bunch in the most recent video when we talked about medical and vocational experts specifically. And there isn't a vocational expert on the face of the earth that would say, and there's an employer out there that would tolerate that. If there is someone who's willing to tolerate it, that means you're being accommodated, and accommodated work by definition is not competitive work. Therefore, that does not equal an ability to work, and that does equal disability. Plain and simple. So, why can't you live your best life possible when you're pursuing a disability claim? Why is this such an important topic? Why does Social Security almost make it seem like it's a crime to live your best life possible in spite of your impairments? AKA, if they perceive that you have, again, these good days or moments, why do they seem to hold that against you in deciding and then usually ultimately denying your claim for disability benefits? Well, as you can see here, the short and truly correct answer to that question is that they shouldn't, and by law, they can't hold that against you. There's an abundant amount of case law, and I was debating whether I would cite to any of it here, but I don't want to go down a rabbit hole we don't want to get into. I am likely planning to do a video, hopefully in the near future, that talks a bit about some of the findings in different federal case laws, and cases that have stood the test of time over the years that we routinely cite to when we appeal cases to different levels, and particularly when we get up to the federal court level, which is a whole nother animal and deserves its whole own video. But there's one, there's a series of cases that speak to this principle that I sort of informally paraphrased and quoted a little bit of it, that recognizes and states claimants do not have to show or demonstrate a 12-month or greater period unmarred by improvement or good days. So, meaning you don't have to show that for 12 months or more straight, you have nothing but bad days, bad moments. Everything is the worst it can possibly be. That's not reality. That's not the way it works. And I know I've probably referenced this in some other videos too, but if you ever have a chance to review any of your own medical records, you will very well notice that no matter how bad things are from your perspective and how bad it is every day of your life, when you look at your own medical records, your doctors aren't making it seem like it's that bad. That's a fact of life too, partly because they're in the business of treating and healing people and making them better, making their quality of life better. So they're not going to come at it with such doom and gloom findings and observations. It's not to say that they won't report when they're observing bad things, particularly in the confines of an exam room and a limited time doctor's appointment that you're being rushed in and out the door half the time. But they're usually going to try to highlight where things are leveled off, stable, normal, negative, whatever it is. But that's also the reality of what people go through. And it's not to say that there aren't people that do have a lot of bad days, that it's rare to find a good day or good moment or something they might categorize as a good day or good moment here and there. But the point being is you do not have to show that you've had 12 consecutive months or more of everything is horrible, the worst it can be, regardless of what your impairments are. That's not reality, and that's not what's required to prove a disability claim. However, the longer and complicated answer is that, as I've referenced many times, and that should be no news to anybody watching this or who's been through this process, Social Security will always scrutinize claims and look to poke holes in them to find a rational basis to deny a claim that should otherwise be approved. And this includes findings regarding the supposed good days or moments that lead to the conclusion of your ability to work a full-time job, no matter how ludicrous that conclusion might be. You have to remember, Social Security, at its core, is an insurance agency, just like any insurance company you have out there. They make money by taking it in and not paying it back out. The money they take in, of course, is the money that's paid by the taxpayers who work and earn income and pay that into the system to pay for the people that truly are disabled and need to receive these benefits. And that is part of the insurance claim process. We're not going to rush in to just pay a claim outright without doing our thorough investigation, due diligence, dotting the I's and crossing the T's. That's what we do. But the problem with Social Security hanging their hat on these, quote, good days and moments is that again, I've probably referenced this, and I will certainly bring this up in more detail when I do the video that I said I would be doing on federal court appeals and case law and all that. Um, Social Security has to build what's called a logical bridge from the evidence to their findings and conclusions. So they have to look at all the evidence that's in the file, primarily medical evidence, medical records from treating doctors, any supplemental forms or statements or letters they write, any statements you as the claimant have made, whether it's at the early levels of a claim in your function report, work history report, any of those consultative exam CEs, and then if it gets to the hearing level, any testimony you give. And they have to make and build a logical bridge to show how do we get from this point to this point. And if it doesn't make sense logically, and they ignore evidence, particularly showing all the bad days and all the inconsistency, they have not built their bridge. And that is their obligation and their burden, not yours. They can't justify denying a claim without showing how they built that logical bridge. So, what does all of this mean for you living your best life while trying to establish disability? Well, first and foremost, and I tell this to my clients all the time, this does not mean making yourself an invalid and exaggerating your symptoms. You're always wanting to be true to yourself, but it also does not mean failing to highlight and emphasize the bad days or moments and the difficulties and limitations that you experience when you have them. It also means not being a hero or pretending something is, quote, no big deal or just, quote, learning to live with it. Those are two of the most common phrases I come across, whether it's in medical records, whether my clients verbally tell this to me, but all of those are huge no-nos. A lot of clients, and I don't just liken this to male and typical, stereotypes of, the macho attitude. Yeah, I can handle this. It's not a big deal. I mean, some of my foremost clients that I've had over the years who happen to be male gender um, are not shy to talk about how their limitations have restricted them, no matter, how big and tall and strong they may have been or currently feel like they still are. They're not shy to talk about how some of these impairments have truly crippled them. And I hate to use that word loosely, but that is the reality of what they deal with. So this is not the forum to be the hero of trying to downplay and pretend, yeah, I've learned to live with it. It's no big deal. No, you need to cry foul about how life has dealt you this horrible hand that you're having to play now, and you don't have any control over it. And you're not asking for sympathy necessarily, nor are you asking for charity. You're asking what's rightfully yours, what you have rightfully earned and deserved because of what you've been through, what you're going through. And, if it's an SSDI claim and you've paid into the system, I mean, a lot of times that's the argument too. I paid this money in, I should be getting it back. And that's the reality of it. But I highlighted these last two bullet points here. I bolded these. You are entitled to live your life and make each day the best it can be. And you are not obligated to share those moments with Social Security because that's not the focus of your claim. So you always want to lead, and I'm going to talk about this when we get to the next slide. You always want to lead with your worst foot forward, not your best. As backwards as that sounds, that's what a disability claim is about. It's about showing how bad things are and how bad they can get and do get. Here are some practical considerations for your claim to allow you to be true to yourself, but also to be true to your claim. As I've stated in so many of my videos in so many different ways, and just to highlight some of the relevant ones, the function report, the work history report, the consultative examination and hearing prep videos, among others, you always want and need to lead with and emphasize your SDLs, your symptoms, your difficulties, and your limitations. Even if they don't seem like a big deal, the consistency of your SDLs is what will ultimately win your case for you. So you always want to lead with how bad or limiting things are. That doesn't mean you have to make it seem like that's what you're dealing with 24/7 because that's likely not your reality. But you need to show without a shadow or question of a doubt, this is my reality. This is what I deal with every single day of my existence. And even if I could wake up one day and feel like it's going to be an okay or even a potentially, quote, good day, it can turn on a dime. It can happen completely out of nowhere. I could be feeling absolutely fine one minute, and the next minute, something completely overcomes me. If I have a migraine headache disorder, a migraine can hit me with no known trigger, and I'm out the rest of the day. Take medicine, have to lie down in a quiet, dark room, and not going to be useful until the next day or even possibly multiple days later. If it's a mental health impairment and suddenly there is a trigger outside my home, I got to get away from everyone and everything and go isolate. Just some examples there. So, one thing I'll also take an opportunity to talk about, partly because I don't really emphasize this the same way in my CE prep video. But all of my current clients, when they have a CE coming up, I'm telling them this now. So I might at some point do an update to that video and maybe even some of the other ones when I see fit. Is I always tell my clients when they're getting asked the quote, yes, no variety of, are you able to do this? Can you do that types of questions. If the answer is no, you can't do something, that's the way you should answer it. But if the answer is yes, you can, but you've got some kind of limitation or difficulty, you don't want to say that little three-letter word that is such a powerful and commonly misused word in this context. You don't want to use the word yes. So if you get an are you able to do this question, you want to lead with the difficulty and limitation you have. That's not answering the question incorrectly or dishonestly even. You're not saying no, I can't, but you're emphasizing again what your difficulty and limitation is. Can you drive? Instead of saying yes, I can, but you're saying I can't drive any long distances. I have to stay close to my home. I can't be sitting in the car for long because my back tightens up. I can't be gripping the steering wheel long because my hands will go numb from carpal tunnel. It's hard for me to turn my neck to switch lanes or check for turning vehicles because I have degeneration in my cervical spine. The bright light is hard on me if I have migraines. Um, I get really anxious and worried when I'm around too many other cars in traffic, so I can't go out during those hours, etc. That answer in that example gives so much more weight and power to your limitations and paints the picture completely different than saying yes, but. So it's a little bit of a psychological trick, but sometimes it's a necessary one. And along those same lines, the last bullet point here is you want to be mindful of how, when, and where you put out in the world your quote, good days or moments when you have a claim pending. I'm looking at you, social media. Now, granted, there's a good amount of clients I've represented over the years, and also granted, when I first started doing this work, social media wasn't the rage it is now. There wasn't much of a platform or audience for social media. I'm still from the Friendster and MySpace era before Facebook, Instagram, Twitter, and X, and all those other ones made their way into the mix. Um, but I do now so more than in the past, and I'm not saying I ever check up on any of my clients or even really ask them about this. But I definitely have clients that either are younger or at least are of an age where they've gone through the social media boom the same as me. And, most of us at minimum have some kind of Facebook presence or something like that. And if we're having good moments in life, whether it's just you did something nice for yourself around your house during the day, whether you went on a day adventure, did some kind of activity, went to a concert, went to a sporting event, took a trip somewhere. We want to share it with the world, or at least the friends that are part of our world. And that's not a bad thing. There's nothing wrong with that. But at the same time, you do have to be a bit mindful of what you're sharing and how you're presenting it when you share it. Because somebody that is claiming disability on the basis of saying they can't be around other people because of anxiety and panic attacks and they don't like to be out in public places, that's posting on Facebook doing just that, that can be a contradiction. Now, you might be asking yourself, and you might be wondering if this is the reason I'm bringing this up, is Social Security really taking the time to check that? And I'll give you, at least from my perspective, the honest answer, which is I don't know. One question that some clients have occasionally asked me, and it's a fair question, but I'm pretty confident in the answer I'm going to give. and the answer I give to clients. Is it possible that the government could be sending out somebody to take surveillance on me, like a private investigator? The answer to that question is highly unlikely. And the reason for that is because, unlike a more intimate and private type of claim setting, like a workers' comp claim, for example, where that kind of activity it runs rampant and is very, very common. When I used to do workers' comp as part of my practice, it was not at all uncommon for my clients in their public places. Obviously, this couldn't be done in the privacy of their own home. It would be a major constitutional violation. But um, private investigators get hired all the time by insurance carriers like that to go take surveillance footage, usually hours and hours of footage that's pared down to a few minute summary that highlights where somebody looks like they're doing something that they've previously stated they're not capable of doing for the purpose of trying to rein in a few dollars on a workers' comp claim that's being paid out for somebody that says they can't work, yet they're out, doing major yard work in the, front or back of their house, or they're, driving to different public places and doing whatever they say they typically can't do. Social Security operates on too grand of a scale to be able to have that kind of oversight. There's millions and millions of claimants that are making claims for money that they've mostly paid into the system. SSI is not direct pay into the system, but it's still the same concept. And the government doesn't have the time or resources to be doing that. But that does not mean that they're not above and can't take the time to check some quick things like a social media feed. And that's why I still would say, at least when this comes up in theory, to be mindful of what you're putting out there and how you're putting it out there. And even when, again, if this is something that doesn't have to be shared now, even if there's an explanation for it. I've got clients, this has happened once or twice on occasion in a hearing setting, usually with a judge. And judges would probably be the most common ones to look at someone's claim and wonder if they have a social media presence to see if they've got something out there that could be, quote, incriminating. So if the question comes up about something that might have been posted on social media somewhere, or even a reference, sometimes it's simply a reference in a medical record that somebody reviewing it will catch, where somebody talks about a trip they just went on when they're, having major back problems, and it sounds like it was a physically demanding trip, or they were in a car ride for a long time. You may very well have explanations for that. And if you can plausibly explain where just because I was able to do this at a given time, that doesn't mean that I could be doing this on a daily and weekly basis, 8 hours a day, 5 days a week, in a full-time job. That does not indicate what I'm capable of doing, or not capable of doing. So, don't grill me about it, kind of thing. But you always have to be prepared to have that explanation in your hip pocket. And some final thoughts, very simply, don't be afraid to be yourself. But again, be aware of your audience when you are yourself, and be mindful of the version of yourself that you put forth. It's sad to think that we're in a day and age, because claims have gotten so much more difficult and so much more of an uphill battle. And there's no two ways about that. That is the harsh reality. Any currently practicing Social Security attorney will tell you they're going out of their way to make these claims more difficult. Whether there's an ulterior motive behind it, we'll never know. And I'm not going to believe that there is. There's a time where I wondered if they were trying to make it more difficult so less and less attorneys want to do this work. And there have been times where I throw my hands in the air and say, maybe I shouldn't be, but I never let it get the better of me. I just keep fighting harder and harder. So again, the harsh reality is, you do have to be mindful of how you put yourself out there when it comes to the claims process. And, it doesn't just go for while your claim is in progress and when it hopefully gets approved, because, and this is another video I'll be doing in the near future too, Social Security can always come back at a later time and check up on you and review updated medical records and see if you're doing better. And again, you should always be true to yourself, but just be mindful of what and how you're putting yourself out there in the world, to not contradict where you're saying you are disabled from working, not disabled in living life necessarily, but disabled in working. And just always have to be on top of that, because you never know who's lurking behind the curtain, and you never know who's checking in on it. So those are pretty much my thoughts on that whole topic. Of course, any questions, like I always say, phone and email are the best ways to contact me. I'm always responding to calls, emails, and texts at all times. And that, my friends, is my presentation. I appreciate you hanging in there with me, and I will see you hopefully sooner for the next one. You all take care and enjoy the rest of your summer.